Jonathan Pollard, non-compete and trade secrets attorney in downtown Fort Lauderdale, Florida. And I'm going to talk today about one of my favorite topics in this arena, which is the use of non-compete agreements in medicine. I've long been a critic of physician non-compete agreements. I believe that enforcing physician non-compete agreements runs counter to the public interest and should be against public policy. There are a number of states that have actually agreed with this. The American Medical Association agrees with this, and a number of states have fallen in line and have passed legislation providing that non-compete agreements cannot be enforced when it comes to doctors. The reason there is to protect the doctor-patient relationship. Florida is not one of those states. In Florida, physician non-compete agreements are, in fact, enforceable to a certain extent. I say this because there is generally a great misunderstanding about non-compete agreements, about non-compete law, about what's enforceable and what's not enforceable. The average Joe has a sort of, non-competes aren't enforceable, that would keep me from working. I've had people say, it's a right-to-work state. Well, that has to do with labor unions. That has nothing to do with non-compete agreements. But even doctors, and even sometimes their lawyers, linger under this false impression that physician non-compete agreements are per se unenforceable. And although that is the law in some other states, and although from a public policy standpoint it would make sense for that to be the law, that is not the current state of the law in Florida. So first, let's take a look at the general landscape of Florida physician non-compete agreement case law. You have a body of case law that basically tells us the following. Courts will enforce physician non-compete agreements provided they are limited in time to a reasonable time and provided they cover a limited geographic territory. So when looking at reasonable geographic territory, that tends to be the big ticket item here, right? You have a doctor, they have a practice in Miami, they have several offices in Miami, and you are looking at starting a practice or going to work for a practice in Margate or in Pembroke Pines or in West Palm Beach. The entire question there is going to be, what's the geographic radius? Say it's a 20-mile radius. And then how is that radius going to be calculated? Is it going to be 20 miles from any of the facilities affiliated with that original practice, or is it going to be 20 miles from any facility at which that particular doctor has done work and treated patients? In my experience, it is generally the latter. So you have non-compete agreements in this realm that are written very aggressively to prevent a doctor from working at a practice that's within 20 miles of any affiliate of his original practice. So if you get into cases involving a big hospital system, big medical system, there are often dozens of affiliated facilities. So more often than not, what I've seen courts do is limit this restriction and kind of pull it back slightly so that it's only 20 miles from those facilities at which the doctor actually treated patients. That's the first piece of it. It will be considered generally enforceable within a reasonable geographic territory and for a reasonable duration. The patient piece of this is where there is a great deal of confusion and a great deal of conflict in the case law. Presently, under Florida law, although patient relationships would be considered protectable based on the text of 542.335 and based on certain of the case law, here is the source of the confusion. There are some cases saying that the patient relationships are absolutely protectable. The practice owns those relationships and can prevent the doctor from attempting to take those patients and take them with him. But there are other cases that suggest the doctor can move to another practice, and if the patients follow him, he may not be violating the terms of his non-compete agreement. There are still other cases that suggest there are public policy concerns here. There's a case involving Humana in which there was a dispute over effectively who owned the patients, and the court ultimately concluded that the insurer didn't own the patients, and that if they did, it would be against public policy because the patients have a right to choose their own doctor and to maintain that relationship. So there is a great deal of confusion and conflict when it comes to whether or not patient relationships are protectable. The third piece of this is going to be, in most instances, referral relationships. Not only are physician non-compete disputes related to patients, they are also related to referral relationships. You have a doctor works in a practice, the practice is very tied in with the community, with other medical providers in the community, and they receive a significant portion, if not the majority, of their business from these other doctors. This is particularly the case when it comes to certain specialists. You have an orthopedic surgeon, you have an orthopedic surgery practice, their source of business is by and large going to come from referrals from other doctors. Well, presently, and fortunately, under Florida case law, the courts have held that referral relationships cannot be protected because you're not talking about a relationship with a specific customer or specific prospective customer. You're actually talking about potential relationships with as of yet unknown potential customers, and that is simply not protectable within the scope of Florida 542.335. So in the end, ultimately, what you have is a scenario where physician non-compete agreements will likely be enforceable for a certain time, certain geographic scope. That geography, based on the majority of the case law, is going to be calculated based on where the physician actually practiced. So although the agreement might be written in a very aggressive manner, it should be enforced based on current case law in a somewhat more reasonable manner, where it's just the radius around those facilities where the doctor actually provided services to patients. With respect to the actual patients themselves and attempting to bring those patients over to the new practice, it's a mixed bag. There's a lot of confusion in the case law. Some cases say patient relationships are absolutely protectable, you can't solicit them. Other cases say if the doctor moves to a different practice and the patients follow him and he's outside of the restricted territory, it's not a problem. Then you have this outlier from, I believe, the 4th DCA, and that's the Humana case, suggesting that all of this raises public policy concerns. Those are the first two. Finally, you get to referral relationships, another big ticket item. Fortunately, for doctors who are switching practices, Florida courts have pretty emphatically held that you cannot use a non-compete agreement to protect referral relationships. I'm Jonathan Pollard, non-compete and trade secrets attorney in downtown Fort Lauderdale, Florida. If you're a physician and you have a question about your non-compete agreement, please feel free to give me a call. Jonathan Pollard, non-compete and trade secrets attorney in downtown Fort Lauderdale, Florida. Thanks for watching. Have a good day.